The clerk's name was Daniel Frey, and he had been in courtroom 9 for 11 days. Not long enough to know everything, long enough to think he did. He had learned to read a room by its silhouettes. Who leaned forward at the counsel table, who checked their phones in the gallery, who arrived early to a hearing, and who arrived at the wire. He had learned that power dressed a certain way in federal court. It wore dark suits and leather portfolios and spoke in measured paragraphs. And that the people who didn't have it sat where they were told and said nothing. The woman in the fourth row had arrived before anyone else. She was not particularly young and not particularly old, dressed in a stone-gray jacket, a yellow legal pad balanced on one knee, a pen moving steadily. She was not looking at her phone. She was not looking at the gallery. She was watching the front of the room with the particular stillness of someone who had already seen everything she needed to see and was simply waiting for the rest to arrive. Daniel had her placed in 30 seconds. A journalist, maybe, a court watcher, someone adjacent to the case who had earned a gallery seat by knowing the right person. Certainly not anyone the room would need to account for. He turned his attention to the counsel table. Marcus Zdrils sat at the defense side with the posture of a man who believed that real estate, development at his scale, $200 million in contested commercial rezoning, constituted a form of immunity. He was broad-shouldered and accustomed to rooms that arranged themselves around him. His lead attorney, Harlan Voss, was the kind of lawyer who wore his reputation like a garment, pressed, expensive, worn in all the right places. Voss had argued before this bench 4 times. He did not stand when he should have sat, and he sat when he should have stood, and nothing bad had happened to him yet. Daniel had noticed this about Voss in the first week. It was the kind of noticing you did before you understood what it meant. Judge Renata Osei took the bench at 9:04. She was compact and unhurried, and the room stood without being asked. She had gray at her temples and reading glasses she used only when she chose, and a reputation that ran 20 years deep in this building. Daniel had heard the clerks in the hallway say that the wisest thing you could do in courtroom 9 was bring the truth with you, because everything else tended to get located eventually. The morning's proceedings were testimony review and motions on document production. Voss was halfway through an argument about scope, his voice carrying the easy confidence of a man who believed the room was his, when he stopped. He had been gesturing toward the respondent's table, where a junior attorney named Priya Das sat alone with 2 banker's boxes and a laptop, and then his eyes moved to the gallery, to the fourth row, to the woman with the yellow legal pad. Something shifted in Voss's expression. It was brief and subtle, and Daniel almost missed it. A recalibration, the kind a person makes when a variable they thought they'd accounted for turns out to be different than expected. And then Voss made his decision. Daniel would think about that decision for a long time afterward. A man chose contempt over caution. "Your Honor," Voss said, turning back to the bench. "Before I continue, I want to note for the record that there is an individual in the gallery who has been taking detailed notes throughout this proceeding. I don't know who she is, and frankly, I don't think anyone does. She appears to have no standing in this matter. I'd move to have her removed as a distraction. She's nobody. This is a closed hearing." The word landed in the room the way words do when they're used as instruments. Nobody. Not an accusation, not an argument. A designation. Daniel looked at the woman in the fourth row. She had not moved. Her pen had not stopped. She finished the sentence she was writing, set the pen down along the spine of the legal pad, and folded her hands. Judge Osei had been looking at Voss. Now she looked at the gallery. Then she looked at her docket. "Mr. Voss," she said, "this is not a closed hearing. It is a civil proceeding open to observation under the standard rules of this court." She paused, and Daniel had been around long enough now to understand that a pause from Judge Osei was not an absence of thought. It was a choice. "Ma'am," she said, and her voice was level and clear, "would you please identify yourself for the record?" The woman stood. She moved to the bar with the ease of someone who had passed through bars in federal courtrooms for more years than Voss had been filing motions. She did not hurry. She did not perform. "Claudette Marsh," she said, "counsel of record for the respondents. I've been admitted in this district for 23 years. My appearance is on the docket, Your Honor, Filed this morning at 7:46. A half beat. I've been observing the morning session. Ms. Das has been handling the argument with my authorization, prepared to address the court directly if that would be useful. The room was very quiet. Daniel looked at Harlan Voss. He had seen, in 11 days in this building, a number of things he hadn't expected to see. He had not seen anything quite like what was on Voss's face in that moment. The expression of a man who understood, with full precision, what he had done and what it was going to cost him. Judge Osei opened the docket on her screen. She read for a moment, then she read aloud. A. Marsh, lead counsel, respondents, bar admission, 23 years. Prior appearances before this bench, she paused, and Daniel thought he heard the faint compression in her voice. 11. I have her appearance on file as of 7:46 this morning. As she states, she set her glasses down. Mr. Voss, your motion is denied, Ms. Marsh is counsel of record in this matter and has every right to observe from any location in this courtroom she chooses. She made a note. I'm also going to find that the motion was made in good faith, given that opposing counsel's appearance was on the public docket before this hearing began. I'll be entering a sanctions order against your client at the close of today's proceeding. You may sit down. Voss sat. He did not say anything. For once this seemed like the right decision. Daniel was watching Ms. Marsh return to the fourth row. She picked up her pen. She wrote something on the yellow legal pad. It was Marcus Driel who could not let it rest. He leaned toward Voss and said something in a voice pitched too loud for the space. Something about the judge. Something about the proceeding being rigged. The specific complaint. Less important than the fact that he said it aloud in courtroom 9. While court was in session, Judge Osei did not raise her voice. Mr. Driel, she said, you are in contempt of this court. That finding is entered on the record as of this moment. She nodded to the bailiff. Your bail conditions will be reviewed this afternoon. I would encourage you to spend the remainder of this hearing in silence. She looked at him with the particular steadiness of someone who has already decided what will happen and is simply waiting for the other person to understand it. Do you understand me? Driel understood her. His attorney understood her. The gallery understood her. The hearing continued for another 40 minutes. Miss Marsh sat in the fourth row and took her notes, and said nothing further, because there was nothing further to say. At the counsel table, Priya Das argued a document production dispute with a clarity that Daniel recognized as the product of very careful preparation. When Miss Marsh had arrived before anyone else this morning, she had not been waiting. She had been working. At 11:15, Judge Osei recessed. The sanctions order was entered at 11:42. Driel's bail review was scheduled for 2 o'clock. Voss filed no further motions that day. Daniel Frey gathered his notes in the quiet after the room cleared. He was thinking about the word nobody, about how easily it had been deployed, and how completely it had collapsed. Not because of drama, not because of a scene, but because it was simply untrue. The docket had known. The bar admission had known. 23 years of appearances in this building had known. The woman in the fourth row had known, and she had written her notes with her pen. And she had waited. And when her name was spoken aloud by the bench, she had not needed to do anything at all to make the room understand what it had missed. He was 11 days into his first rotation. He thought he might finally be starting to understand what he was watching. He took the long way around to the clerk's office, past the window that looked out over the plaza, and he thought about what it meant to sit still in a room and be certain, not loud, not insistent, certain. The kind of certainty that had nothing to prove, because the record had already proven it, and the record was permanent, and the record did not care who had assumed. What about a woman with a yellow legal pad in the fourth row of courtroom 9 on a Tuesday morning in April? He thought he would remember this day for a long time. He was right.